over the course of the last couple of days, we've shot a series of short video clips seeking to dispel popular misconceptions about a variety of issues and concepts and principles that have come up during the course of the Oregon standoff trial. So in connection with those other videos that this kind of goes hand in hand with, we're also shooting this little summary nutshell regarding legal tools for federal grazing allotment owners. One of the most important things to understand, and we shot a video clip about this, is the whole concept of prior appropriation and beneficial use. And that's how ranchers have acquired property interests in those federal grazing allotments, either they or their predecessors in interest, by putting those grazing allotments to beneficial use, going way back under a series of congressional acts over the course of a century or more that serve as the basis for settlement of the West. In many cases, those were homestead acts that provided a means by which people could come out west and they could stake a claim to a homestead, they could take possession of it, improve it, put it to beneficial use, prove up on the homestead, and ultimately acquire a deed, a patent to the homestead. That became private property for them. But over and above those homesteads and the land and the water rights that went with those, there's also this concept of federal grazing allotments. Now, the thing that you need to understand is that this federal domain is basically a bundle of sticks that involves split estates. We've got the surface estate, which is the land itself, the subsurface estate, which includes minerals and oil and gas, and then we've got the forage estate, which includes the grass and the other forbs and the vegetation that can be utilized by livestock for grazing. And we've got the water estate, and we've got the timber estate, and we've got the hunting estate, and we've got the recreation estate, and we've got the access estate. And those are all part of the bundle of sticks. Those are all separate split estates. And so ranchers acquire a property interest in the forage and water estates on these grazing allotments. And they do that by prior appropriation and beneficial use under these congressional acts that were enacted to do that. And that's the important thing to understand, that as part of this discussion, for purposes of this discussion, we're not talking about the property clause of the Constitution, which might limit or prohibit federal jurisdiction over all these lands. We're not talking about a transfer of federal lands to the states. We're talking, for purposes of this discussion, we're operating and discussing based on the conditions that exist on the ground today, the realities that exist. So basically these federal lands, to a large extent, especially on the BLM, are managed under the Federal Lands Policy Management Act, FLPMA. And so we're going to talk about how all of these concepts basically apply under FLPMA instead of some other theoretical approach that is maybe well and good and may happen at some point in time, but for purposes of this discussion, we're talking about the conditions that actually exist on the ground today under federal jurisdiction or alleged federal jurisdiction on federal grazing allotments. And so we want to talk about some of those tools. So it's important that you understand that whole concept of prior appropriation and beneficial use. And the reason it's so important to understand that is because FLPMA itself was enacted in 1976, and it basically changed the way grazing allotments were managed in the West. It applied a whole bunch of new requirements and new regulations and all of that. And that's part of what ranchers often struggle with, is these new requirements under FLPMA. And we hear so much about FLPMA, but the important thing, and NEPA, those are a couple of different acts that we hear a lot about, and there are others as well. But the important thing to understand is that FLPMA itself says that the act is subject to all valid prior existing rights. So if you have valid prior existing rights that you or your predecessors in interest acquired in federal grazing allotments prior to 1976, those may be the valid prior existing rights that FLPMA is subject to, which means that your rights trump a lot of those regulations. That's what it means to be subject to those valid prior existing rights. The other tool that you need to understand, and I say tool because one of the most important legal tools and operating tools that you can have is a clear understanding of these principles, to educate yourself. And I encourage that if you have the opportunity to do it, read the writings of Dr. Michael Kaufman. He has a number of articles that are published in Range Magazine, or attend a Storm Over Rangeland workshop that Dr. Angus McIntosh often presents at, or read his dissertation, or go to a workshop sponsored by the Allotment Owners Association and educate yourself about how these principles apply, because that becomes one of the most important tools available at your disposal, is a clear understanding of how these rights work. Then in addition to that, what you need to understand under FLPMA is that it requires that the federal government coordinate with local governments. And you need to understand how powerful that coordination tool can be, especially in combination with a solid understanding of your property rights and interests in grazing allotments. And then the other thing that you need to understand under FLPMA is that the federal government is obligated by statute, by congressional mandate, to manage these grazing allotments and these federal lands in the West and the resources for multiple use and sustained yield. And that's an important way that you can utilize FLPMA to your benefit and to protect your interests by requiring that the federal government do what Congress says it's supposed to do, which is manage these lands and resources for multiple use and sustained yield, which is exactly what ranchers are doing on their federal grazing allotments. So now what I want to do is talk about some of the other tools that are available. One of the things that often happens in this relationship with the federal government is that conflicts arise. Sometimes the federal government takes issue with some of your practices on the land, and so they might send you a letter or a notice as part of some kind of administrative procedure or proceeding, and they want you to take action about that. Or you may have a bone to pick with what they're doing, what they're saying. It's not uncommon for ranchers to feel like the federal government is engaging in double standards. I hear that a lot, especially when it comes to the whole issue of wild horse management. On one hand, they're trying to require ranchers to manage their livestock in one way, and then the federal government does something completely different with respect to wild horse management. And so it becomes an obvious double standard. What I'm suggesting is that you can use the administrative procedures and proceedings to seek redress of some of those kinds of issues and grievances. And that's an issue we're going to come back and talk about a lot more later, is this whole idea of seeking redress of grievances as a tool for dealing with the federal government on your grazing allotment. One of the other things that I want to talk about briefly is the concept of litigation. So litigation, from my perspective, is something that you should try to avoid at all costs. You shouldn't be afraid of litigation, but you should do everything you can to avoid it. One of the biggest reasons to avoid it is because it's so expensive. Attorneys cost a lot of money. I'm here to tell you, I used to have a hat in my office that said, "Talk is cheap until you hire an attorney," and that's the reality of it. And one of the best examples of that involves the Hage family in central Nevada, and they've been engaged in litigation with the federal government for something like 40 years. They sued the federal government, alleging that the government had engaged in a taking of their property rights and their water rights, and they actually secured a judgment against the federal government in the D.C. district in Washington, D.C., the Court of Claims. And they secured a judgment for something like $4.5 million plus interest and attorney's fees. But then that got appealed. And then the federal government sued them in Nevada, alleging that they were in trespass. And so it all adds up to a lot of attorney's fees and costs that are hard to absorb. And the thing about ranchers is they don't have access, generally speaking, to this tool that most environmental organizations are utilizing, which is the Equal Access to Management Act, whereby environmental organizations sue the federal government in friendly litigation oftentimes. It's called sue and settle, and they try to dictate land use policy where there's no one else really opposing it, and they use that basically as a hammer to secure what they consider to be a favorable ruling that then becomes law through the court system, and then they turn around and get the federal government to reimburse all of their costs and attorney's fees. And they're able to do that because they set up these nonprofit organizations to do that. So they are able to have access to this Equal Access to Justice Act that most attorneys just don't have access to. And that's what puts ranchers at a great disadvantage in this whole discussion, especially when it comes to the legal system and how it operates in federal court. So litigation is something that you need to understand. It's a tool. You need to use it very wisely, very carefully. The Hages, again, they secured a judgment in the Court of Claims in Washington, D.C. They secured a judgment, a favorable judgment in the Federal District Court in Nevada, but then that judgment was appealed to the Ninth Circuit, which reversed and remanded it back to the District Court, and it just goes on and on forever is the problem, and it's very expensive. So I encourage you to seek to avoid it. Get your ducks in a row, understand your rights, and what I'm going to suggest is if you understand your property rights, then one of the most powerful tools you can use is this tool of coordination. Approach your county commissioners and help them understand how coordination works. Educate yourself about that, help educate them about that, and then use that coordination tool in combination with an understanding of your basic fundamental property rights on the grazing allotments so that you can have a better working relationship with the federal government in terms of managing not only your allotment but adjoining allotments and everything in your area. So one of the other things I want to talk about in combination with all of this are what we call other options, and they're legal tools. And one of the legal tools that I want to talk about is this whole concept again of a petition for redress of grievances, which I think is a very powerful tool that ranchers seldom understand and can be used to help protect their interests. We shot a completely separate clip about the concept of seeking redress of grievances, explaining how that works in a general context. It's a concept that has a basis in the First Amendment to the Constitution. Now, I encourage you to watch that other video that talks about that in a general context. Then there's yet another video that gives a whole bunch of different examples about how it works. And what I see in those videos is that there's a variety of ways that you can seek redress of your grievances and petition to do that. And that can include everything from a phone call, an email, a text, a letter. All of those things include the concept of petitioning for redress of grievances and fit within that umbrella. But I suggest that you utilize the language of the Constitution and put together a petition for redress of grievances that applies to your relationship with the federal land management agencies that help manage your grazing allotments. And so, especially if you have any kind of conflict with them, I encourage you to use a petition for redress of grievances to document those conflicts, to put the government on fair notice of what those conflicts are. And the other thing that's important to understand is if you put together that petition for redress of grievances, then the government is on notice, and it's unlawful for them to then engage in recrimination and retaliation against you. That's one of the most important ways that a petition for redress of grievances can protect and help you. I'm out of time. I wanted to talk about a couple of other tools, and I wanted to talk about grazing fees, but I'm out of time.